learners, this week we've been studying about Crystallex versus Venezuela. In the earlier videos, we looked at the factual matrix of the case, and then we also looked at the claim of Crystallex relating to FET violation. In this video, we will look at two other claims of Crystallex, that is with regard to the violation of full protection and security clause and then the violation of expropriation clause. So, with regard to the FPS treatment, lack of XPS treatment by Venezuela, Crystallex argued that Venezuela had not provided stability by failing to give a secure investment environment for Crystallex. So, Venezuela questioned it. FPS clause is something related only to the physical protection of the property, and that was not violated in this case. Whereas Crystallex stated that it is something that extends beyond the physical protection of property. But so since Venezuela and Crystallex were taking two extreme arguments, Tribunal had to decide what is actually the scope of FPS clause. Tribunal looked at Saluka Tribunal's decision, Rumeli Tribunal's decision and other tribunals, and also it gave weightage to the words protection, security, and then Tribunal, in this case Crystallex Tribunal, concluded that this clause is limited only to the physical protection of the property, and then consequently it stated that there is no violation of FPS clause in this case. Then with regard to the question of expropriation, Crystallex claimed that its right to mine under the MOC was sort of expropriated. Its contractual rights under the MOC was expropriated by Venezuela. So, primarily the tribunal had to look at the question of whether was there any contractual rights that was with Crystallex and was that expropriated. So, then the tribunal looked at the definition of investment in the PIT, and it stated that the definition of investment included contractual rights as well, and it did not contain any limitation with regard to the type of contractual rights or the measure of contractual rights. So, therefore, the tribunal stated that this is capable of being expropriated. Crystallex possessed certain contractual rights under the MOC, and that is something that is capable of being expropriated. So, that is with regard to the first part. So, then if it has a contractual right that is capable of being expropriated, the next question is, was those rights expropriated? So, Venezuela here came up with an interesting argument. It said that the Crystallex did not possess a right to mine because even under the contract, Crystallex would get the right to mine provided it has obtained the permit to exploit the gold concession. Right. So, since that permit was never obtained by Crystallex, Venezuela's contention was it did not have a right to mine. So, here tribunal had to decide with regard to the question of expropriation on the basis of Venezuela's conduct. So, there were a series of actions that had happened. So, tribunal what it did was it sort of grouped Venezuela's action into three categories. Tribunal at the outset agreed that giving a right, right permit is something that falls within the prerogative of the state. State could grant or state could refuse, and as long as state gives, it should follow a due process and all of that. This is what it looked at while examining FET clause. But then the tribunal stated that the denial of permit letter and the action surrounding it, that is something that belonged to the first category. So, denial per se did not mean that the state has expropriated, because Crystallex did not have a right to permit. That is what the tribunal stated. It did not have a right to permit, but in the way that the denial of permit had happened combined with other actions. I mean, in the earlier issue of FET clause only, the tribunal has categorically stated that the circumstances surrounding a denial of permit was unfair to the claimant. So, therefore, this combined with other actions, it is something that could rise to expropriation. With regard to the second category of actions, like I told you, tribunal what it did was it categorized a series of actions into three groups. With regard to the second group, that is with the actions of the government post the denial until the termination. Basically, the actions where there were many statements given by the public officials against the project and against Crystallex. So, that in tribunal's opinion encroached into the contractual rights of Crystallex, and also to some extent result in gradual devaluation of the investment as well. So, that the tribunal found to be expropriatory. With regard to the third category of actions, that is the action surrounding the rescission of the contract. So, that also the tribunal relied on the internal document and then the internal CVG document, and that was something that happened because of the decisions of the higher officials, and that also the tribunal found to be expropriatory. Basically, Venezuela was arguing that something that is merely contractual, you cannot consider that to be an expropriation, because for expropriation to happen there must be an exercise of sovereign authority. Then the tribunal stated that MOC was rescinded purely on the basis of a contractual reason, right. So, the contractual reason was that Crystallex did not do anything under the contract for 1 year, and therefore clause 24 of MOC was invoked and all of that. Prima facie, it may appear to look like a contractual measure, but the tribunal said that if we look at the agencies that were involved, Ministry of Mines was involved, Ministry of Environment was involved, Venezuelan president was involved, CVG was involved. Since all of these agencies were involved, and the decision to terminate the contract, as made evident from the internal documents of CVG, had lot of an influence from the higher officials' decision. So, therefore, even though it was technically a contractual measure that resulted in it may look like a contractual reasoning for the termination of MOC, it has a sovereign color to it because of these many agencies being involved, and it was an influence of the higher official that led to CVG to to sort of terminate it. So, this in tribunal's opinion is something that amounted to expropriation. So, this is how it concluded. The tribunal rejected the claim of Crystallex with regard to FPA standard, but it found a violation of FET clause as well as the protection against expropriation. In the next week, we will be looking at one other case. I hope all these cases are making it clear as to the interplay between investment agreement, bilateral investment treaties, investment contract, and the cause of protecting the environment. Thank you.